Hello, everybody, and welcome back to the Layman's Law School. And we got some interesting stuff to get into today. We're going to cover the Karen Reid case again and kind of get you up to date. But before we do that, as always, as our Friday tradition, it's been a hard week, and that's why I'm introducing us today, because Mr. Chace Hawk over there is a little bent out of shape, cross-eyed, but, you know, he's making it. So he's got some clips for us, and we're going to talk about what the prosecution has done right, wrong, and what the defense has done right and wrong, and maybe a little bit about what the judges let in and what shouldn't have been let in, maybe should be let in, that kind of thing. So before that, let's get this going, Chace.
Let's get the real party started.
Let's get the real thing
That's
going.
Right.
I know this is your favorite part of the week.
Mm-hmm.
You're like Garfield,
Wow.
except you hate Fridays.
Yeah.
Cheers, gentlemen.
All righty, nice.
Yeah.
I know
So-
you put that to the
Delicious.
side. At least I get you to get a
So
sip of it.
I want to, there's this. I've seen some comments on the YouTube channel and stuff like that, and it's
the
totally fine.
YouTube.
Yeah,
the-
on the YouTube.
On the YouTube.
Yeah, on the channel, and I want everyone to recognize one fact: we are trial lawyers. Okay. Posing as podcasters, because if we don't actually,
That's very true.
we don't actually put it on a calendar and pay for it, we won't show up to sit and have drinks with one another once a week.
That's true.
And so this is a bonding experience for us, a team building exercise for us, and we sit around and have a few drinks, have a few laughs, hopefully, and hopefully entertain a little bit. So.
And we bring some educational aspects to
Hey,
it.
that is the hope.
Yeah,
that is the hope.
We really try, at least.
I never said I was a smart man.
Well, the Karen Reid trial has been sort of, drawing a lot of attention in the news media for good reason. There've been some serious allegation of misconduct by a lot of the Boston police officers that are involves the murder of a Boston police officer. And, we've got a long way into this trial. I mean, where do you guys, I know you guys have watched, most of the coverage, or at least the highlights of the testimony. I mean, after the openings and after, I guess, this day 16 is where we're at right now. How do y'all feel about the defense's case, about the prosecution's case?
Go ahead, Shawn.
I would say that in the totality of things, there is significant reasonable doubt, and all you need is one juror to say that there's a reasonable doubt as to whether or not she did this. And I think that there is plenty of evidence that has been put in, and especially on cross-examination, that gives jurors that reasonable doubt. And I think a lot of people look at the things through, well, that doesn't prove that these parties had something to do with it, or we're not trying, a defense attorney is not trying to prove a case against anyone, trying to pin it on anyone. They might have a narrative that leads towards some person or group of persons, but all they're trying to do is ferret out the evidence that is, favorable for their client, and that points in a different direction. And all of these inconsistencies and things that happened, and text messages and phone calls and that were deleted or weren't deleted, all of these things, when you put them all together, it's hard for me to believe that there's not a significant number of the jurors who are saying, there's some doubt here.
Right.
And we're reasonable people, so it must be a reasonable doubt.
Yeah, I agree with you, Shawn, and I think that it's been a master class by the defense team on how to try a case in regards when you have questionable facts and questionable people. In my opinion, the defense, what they have done is they made it very clear from the beginning to inform the jury and continuously talk about it, and use the repeating of the phrases that that we're trained to do. Looping. But they constantly are talking about how we don't have to prove that Karen Reid is innocent. We don't have to prove that Karen Reid didn't do this. That's not the level. And they are just saying it all the time. And what the prosecution has fallen victim to, in my opinion, is they've fallen into that trap of they are on the defensive. They are trying to fight what the defense is saying. They're not proving their case. All they're doing is trying to combat the defense's theory, but they're not showing their own theory. And the way that the defense has done that, they came in, and you can just see it on the jurors. You can see it in there. They have an air of knowledge, right? The jury believes that they know things.
Right.
And one of the things I think that the defense made a mistake on, but I understand why they did it, is they went way too hard and too aggressive on Jen McCabe. He went a little too rough. But the reason he did that is because he knows that the jury sees him, this is the defense attorney, Jackson, as the person with the knowledge, the person who knows it, right? And so he does that because McCabe was the only, she held her ground relatively well. And so by the defense, I thought a little too aggressive with her. They're still trying to diminish what the jury believes she knows, or she's telling the truth. And I'm the attorney, and I know I'm the saving grace here, is what he's coming in. He's the white knight, right? And he's playing that part to perfection. And the prosecution is just limp. I mean, that's all I can say. They got no passion, no nothing. There's no passion. To me, they don't believe in their own case. That's the problem.
Yeah, I think that they know that they have a tough case to bring, and it makes them. And it's incredibly difficult not to be able to prepare your witnesses. So, like in the prosecution,
I'm not blaming them.
I mean, tell me, Shawn, in the prosecution, typically it's not a great idea to go and get every one of your witnesses and have a long discussion about how to testify. I mean, because they don't have attorney-client privilege in that environment. You have to. They have to be able.
We've met with witnesses all the time. I never had any problem, but I wasn't trying to craft a story that fits. It was just hey, we need to go over what you said in the past. Is all this still clear? Do you remember anything differently from this? Well, then why do you remember it differently? And obviously as a prosecutor, we had, there's always the people that the story gets better as time goes by.
Absolutely. Evolving stories.
And we have to, try and squash that.
Yep.
And,
we understand that kills credibility.
Yeah, we understand that you hate this person for some reason, whatever it may be. But these are details that don't sound,
And if you say them, they're not going to believe anything you say.
Yeah, and then we follow up with, all we want you to do is tell the truth. And most of the things we're telling them about when we're meeting with them is just that, familiarizing them with the courtroom, that, we want you, when you're answering questions to, from us, to speak to the jury just like they're your friends.
It's more
things
getting
like
them comfortable with the surrounding and the area, and I'm sure that both parties did that. I mean, you have to. It's just like whenever you have a meeting, whether an attorney or anyone really in a professional setting, if you're at your house or in somewhere comfortable, you're much more inclined to talk a little more, maybe be a little bit more open.
Sure.
And if you're at somebody else's place where you're a little uncomfortable, nervous, you kind of clam up. So you want your jurors to be comfortable, and like you said, that's a very good example, is they have to talk to the jury, and I think that they've done all the witnesses have done pretty well. I thought Jen McCabe did a really good job. She's got two monsters coming after her, and she held her own.
She's
in my opinion,
a little snarky. I think
absolutely she was, but she didn't.
What do you
she
expect?
didn't cave. She didn't cave.
It was the stereotypical person that I would have believed to have come from Boston.
Right. A lot of people in her situation would have broken down and almost, not that she's even lying, I'm not even saying that, but kind of given up in that hostile environment of just, okay, what the hell do you want me to say? That kind of attitude. But I was impressed with her fortitude, and she stood strong, and I still don't believe her. But I thought that she fought well against two seasoned, very good attorneys.
Yeah, and so when you're attacking a case like this, if you're on the defense side, okay, and Shawn, correct me if I'm wrong, one of the angles you're always going to take is the quality of the investigation, right?
Sure.
Yeah, and then the credibility of the witnesses. If you have poor sort of credibility for the people that, or poor facts that show, that indicate that your client might have some sort of guilt in the case or whatever, and the defense, I believe, has gone witness for witness and been able to dismantle almost every single person,
Sure.
one way or the other, about what was said that night, about did he do it, didn't he do it,
and I think that
or,
when they talk
did
about
I do
it,
it, did I hit him,
and you're
or
getting in the weeds,
I
right?
did it,
The
I did it.
defense is
Yeah.
pulling you into their story, they're muddying the water.
Yeah.
And I think that's why I keep going. Every time I watch anything on it, it is a feeling of the prosecution trying to get their breath, trying to catch up.
Yeah.
And and this is the prosecution's case. We haven't even gotten to the defense side.
I say I'm glad you framed it that way, because I thought about an interesting way to maybe look at this would be looking at the 10-point must system. Okay, I used to box, I used to fight. You talk about they're trying to catch their breath. Best defense is a good offense.
Yep.
Okay, and that's what's happening is the prosecution or the defense is actually, making points about how bad the investigation was, how unreliable the witnesses are, all these really bad facts that point to other people.
And you don't have to do this as a defense, but they have done a good job of giving a alternative theory of what is possible.
Yeah, but I think when people are watching this,
they want that.
If people are watching this at home, to understand what the 10-point must system is that every round you see a boxer fight, right? One guy gets 10, one guy gets 9,
right,
unless he gets one of the fighters gets knocked down, right? Well, if you're looking at these witnesses and you're looking at these days in court, right, and you score it, who won that day, defense or the prosecution? You give it 10-9, 10-9, okay? It's not going to be who has got the most points at the end of this trial. In other words, who won the most rounds,
yes.
right? It's not going to matter if the prosecution won.
That's civil law.
Yeah, exactly. 65% of the rounds, right? They have to win, a substantial portion.
Right.
There can be no question.
Well, and it's really, I don't think that I learned it anywhere, or were taught it in a book or anything, but it seems like most defense attorneys have a good working knowledge of, what to do is, number one, we want to, in a trial situation, we want to try and prove our client innocent.
Right, yeah.
If we have.
If
we can. Some cases, there's just not the availability of that.
Because you can't prove the negative.
Exactly. In cases where, you have a solid alibi and you can prove that they weren't there when this is alleged to have happened, maybe like that. But you try and, prove your client's innocent. You obviously try to, challenge the credibility of the witnesses and what they are saying, which may be, through a narrative that they have a motive, to lie.
Sure.
As well
and
as
that's a good
showing
another thing on that, Shawn. Sorry to interrupt you, but a lot of people are confused. You don't have to have a motive. You don't have to prove a motive.
No.
It just helps.
Oh, absolutely. And then, the last thing that every attorney is always going to hit on is, the police investigation. Because there is always more that could be done in a police investigation.
Just like a case.
Yeah,
I mean,
because of, resources, time, timelines, things that it's just never going to be done. So even in a case that something, somebody is overwhelmingly guilty, you can go up to an officer and say, well, you have all this evidence, but you never did a photo lineup with the alleged victim. They never picked them out of a lineup and said this is them.
Right.
Just things like that.
Sure.
You were taught that in the academy, that this was, or in investigative school.
Right.
You could do this. This was a way to positively identify a person who committed a crime.
But you already had your mind made up, didn't you?
Yeah.
that kind of thing.
Just things like that. And all of those things in totality are simply trying to establish reasonable doubt that this person committed this offense. Not trying to prove that any of these other people that actually did it.
Right.
Exactly. And there's just so much, afoot that it's tough.
All right. So let's bring some specific examples up about that, because I have some real issues with some of the witnesses or the witness order in which Lally kind of put people up there. First of all, he puts the brother up first. Okay, the brother's just kind of telling a story about who he is. I mean, they had almost no sort of value with regard to that I was aware of when I watched it, as to them sussing out who did this, right? And then they go through a number of other witnesses.
There's some things like in you want to humanize your victim. You have to, there's weird things that have to be established in murder cases too. Like someone has to testify, at least in Georgia, that he is a human being.
Yeah.
And it's weird. It's a weird question. Everybody knows that he's a human
That's
being.
why people always think
testify.
attorneys ask stupid questions.
No,
I know we do,
like,
but we have to ask them.
It's either going to be, his mom testifying that he's a human being, and here's the in-life photo of him, or a medical examiner saying, yes, this is a human being, and everybody says, we know it's a human being, but just weird stuff.
But
that
if you
have to
don't, what
ask.
happens if you don't do that?
The case gets reversed on appeal because there was no evidence to support that element of the crime.
Exactly.
And then they have to do it all over again.
So, people out there listening, if you're in a deposition and in a court scenario, whatever, and you get an attorney that you go, this guy's the dumbest person in the world, or girl, you just
They might be.
They might be.
But give them a little slack because they might just
have
be
to
asking
ask the question.
things that they have to ask.
Yeah. And sometimes you also might get a police officer, and he's standing up there, he's going to testify in a murder trial, and you might listen to what he's got to say and say that guy might be the dumbest SOB I've ever seen, because they called Officer Sheriff. Now he seems like a lovely man, but he did some things that are.
Who are you talking about? Which one? Officer?
This Officer Sarah.
Sarah, okay,
Steve
gotcha.
Sheriff. He was one of the first people there on the scene, and I don't know how many times he's testified before, but when I
hopefully
heard
not
it,
many.
Yeah. So on his direct, he did some things inconsistent with all the statements he'd made before. As a police officer, he should have known to absolutely testify with the same exact way, or had some explanation as to why he's changed his story. And he didn't do that. And the defense were experts in actually picking up on this and exploiting it to the fullest. Not only his credibility and some of the statements he's alleged to have attributed to, or that he attributed to Karen Reid, but also just, he's also at the same time attacking the quality of the actual investigation.
Sure,
I thought he
absolutely.
did a great job, but this is the first part of his testimony, I think, on direct. I was going to play for you guys, and I'm going to just show you what the defense does with it.
After the fire department arrived and they sort of take over resuscitative efforts with regard to Mr. O'Keefe, what, if any, observations did you make of Miss Reid and what she was doing or saying at that point?
Miss Reid was visibly upset. She kept saying, this is all my fault. This is my fault. I did this. And she was very hysterical.
And
She kept asking, he's dead. Is he dead? Is he dead?
And with that specific phraseology, that's something that she kept saying?
Yes.
And by your repetitive nature, I'm assuming it was something that she said more than once, correct?
Several times, correct.
And when she's saying this, can you describe sort of how she's saying this? I mean, is it a whisper, is it a scream, or is it something in between?
She was yelling pretty good.
And with regard to her repetitive question as far as is he dead, what, if any, response did you provide to her in regard to that?
I just said they're doing the best that they can. I don't know.
All right. So he's basically attributed a statement of, this is my fault, I did this, to her. And this is what the defense did with it. And what you're going to see first is him sort of setting this officer up. And he starts off with the call log, the 911 call log.
What is a dispatch log? Can you describe to the jurors?
Just notes saying what time calls come in, and sometimes a short synopsis of what happened on the call.
It's an official document generated by the Canton Police Department, correct?
That's correct.
And it's kept in the ordinary course of business?
Yes.
It's created at or near the time of the event that it's recording?
Yes.
All right, there's your series of weird and inane questions. Y'all don't understand why they're asking. They're asking those questions because those are the foundational questions required to overcome hearsay.
And it's supposed to be accurate?
Yes.
Is that yes?
Yes.
Okay.
Yes, sir.
And in fact, what it has is the dispatch details of the event that's in question. Whatever officers show up, what time they show up, the order in which they show up, the location to which they're dispatched, things of that nature, correct?
Yes.
Have you looked at the dispatch log in this case?
No, I have not.
May I approach you on it?
Yes.
This has been pre-marked as Exhibit 27. Take a glance at that and tell me if you recognize that document.
Yes, sir.
How do you recognize it?
It looks like the log in question.
Oh, okay. So that's the dispatch log for what date?
The 29th?
Do you see your name somewhere on that dispatch log?
Yes.
To the right, one of the 3 officers that was called to the scene.
Yes.
And that looks like the dispatch log for the call out that you were testifying about yesterday. Is that right?
That's correct.
May I approach you on it?
Yes.
May I publish this as we...
Yes.
And see, what you're listening to here is a lot of formality that's actually required foundational.
I'm going to make I approach one more time.
Yes.
Yeah.
Everybody knows
This
this
is not
was
an
most
eye
likely the
contest.
call log from this case.
I should say. Oh, look at that. The magic of technology. All right. You can either look up on the screen or look at the dispatch log that's in front of you. I'll try to look at the one on the screen, but my eyes aren't that great either. If you look to the right, there appear to be 3 entries for the dispatch of the officers that were on the scene about which you testified yesterday, correct?
Yes, sir.
And in fact, it has this dispatch log shows that you and then Officer Mullaney and then Sergeant Good all arrived to 32 Fairview that morning within 7 seconds of each other, correct?
That's what it says, yes.
It actually has Officer Mullaney arriving first at 6:09:26. You see that?
Yes.
And you see that it also has 3 seconds later at 6:09:29 you arriving. Is that right?
6:29 it says. Excuse me, it's 6:09, yes.
6:09 and 29 seconds.
Yes, I'm sorry, yep.
That's okay. And then it has Sergeant Good arriving 4 seconds after you at 6:09 and 33 seconds, correct?
Sure, yep.
So all 3 of you, according to the official document generated by Canton Police Department for this event, has Officer Mullaney arriving first, you arriving second, Sergeant Good arriving third, all within 7 seconds of each other, correct?
Correct.
That is completely false, isn't it?
Yes.
Yeah, you've looked at your dispatch, your dash cam, correct? And clearly, we saw it yesterday. You arrive, and there's nobody else on scene.
Correct.
That was at about 6:10 a.m. that you arrived, correct?
About that, yes.
And then Officer Mullaney actually arrives after you about 6:11 a.m. Is that right?
Yes.
And Sergeant Good does not arrive, according to your own dash cam, until about 6:16, a little after.
All right, I'm just going to pause it there just for a second. So what's important about that?
I'm going to tell you, from my experience, there's nothing important about that at all.
Yeah.
It's just the building of a theme of inconsistency and false records and everything like that.
Yeah.
What I can tell you personally is that the computer-aided dispatch log is not the official document that's supposed to be true and accurate and correct. I mean, it's if you've already got the body camera and no one has said we all arrived at the same time, there's no significance in this to me.
Sure.
Because dispatchers are sitting there answering the radio, answering the telephone, typing things in, putting out calls for service. So when they hear that,
So-and-so's arrived on
Unit
scene.
101's on scene,
Yeah.
Unit 502's on scene, eventually at some point they are taking little notes and everything, and then when they get a minute,
Right.
boom, all 3 of these officers are on scene. That's why it shows up at the same time. But in terms of, criminal defense, you are building a repetitive theme of you guys don't do it the way it's supposed to be done. This is supposed to be instantaneous information,
Correct.
recorded,
Official.
just to continue to build reasonable doubt about the investigation, about the, how anything was done with this agency and this investigation.
Yeah. And he doesn't necessarily do a great job of handling it, but he's not a professional witness. And, he didn't explain it the way you did, right? I think he should be able to, but he did not. But yeah,
I certainly would have been able to explain it.
It's not very complicated.
I mean, in 2 sentences, like,
Right.
But the thing is, it's not, to me, it's not probative of
I agree.
anything.
Right.
Of this doesn't show any type of cover up. It's just another. They're trying to build,
muddy in the water.
Yeah, they're trying to build a wall of bricks.
All
right,
This
so
is just one little brick.
But it also helps to destroy the credibility of that particular witness, okay? Because he's associated himself with that document. He's in there. His name is in there. This is supposed to be the official document, and that's false, isn't it? Yes. Okay,
Sure.
because he's able to lead the witness. He does a great job of it. But this is all being done for the purpose of being able to say in the very first official document that you guys generated in the investigation of this murder is completely false and wrong. Isn't that right? And the truth of the matter is, that's true. Now, there's a reasonable explanation for it.
Yep.
Sure.
But if he's asking that question, is that true? That's right. But I want y'all to continue to listen to these questions and see if you, and just sort of let me know when something raises your eyebrows. It's like you expect something else to come.
A little after 6:15.
Yep.
All right. So right off the bat, the official Canton Police Department dispatch log, one of the first documents generated in any investigative event, that's completely wrong, right?
The times are, yes.
Well, the times and the orders, right? I mean, not only did Officer Mulaney not arrive first, you arrived first.
That's
and
correct.
then he arrived.
Sure.
So that's two things that are wrong about just that, correct?
Sure.
And then it has Sergeant Good arriving 4 seconds after you, which is also incorrect.
Yep.
He didn't arrive until about 6 or 7 minutes after you, right?
Sure.
All right. Have you reviewed this document in the past?
Yeah? No.
You've never seen the dispatch log?
No.
Did you ever seek to make sure that the dispatch log that's so important and so vital in an investigation was actually accurate?
You could pause
before
it
was
right
turned over
there.
to the defense, for instance?
No.
This is the defense attorney testifying. Mm-hmm. And he's doing a fantastic job of it. He is telling the jurors that
This is vital.
This document that doesn't amount to a hill of beans, really, in this particular case, is vital and the most official document of the entire case, and it's false. He's doing a good job of getting information in the mind of the jurors. And I think he's going to respond to it that, it's just wrong.
Yep.
Yeah. So I mean, but that's a good point. So this brings up a good opportunity to talk about something. So everybody talks about the judge, and everybody seems to be confused about the role of the judge a little bit here. Okay, and the way that I've explained it to people is that it is a pickup game of basketball where there's a ref out there. All right, but you still have to call your own fouls.
Mm-hmm. Sure.
Right, and what we have here is we have a defense attorney who's testifying. He's asking questions, but what he's doing is testifying about the importance of that document, right? But the only person that can come in and say, "Hey, that's a foul. You can't do that," is Lally, is the prosecution. And then that's when you hear the judge come in and say, "Yeah, okay, I agree. That objection is sustained. You can't ask a question that way." And so, we are Georgia, South Carolina attorneys. This is happening up in Massachusetts. We are not licensed up there, but there's some strange rules up there where they don't do speaking objections in front of the jury. There's a lot of sidebar stuff.
I've noticed that all they say is objection.
Yes.
Yeah.
And the judge, for some reason, just knows what that objection is related to. Obviously, speaking objections are frowned upon anyway. But
It's good and bad on
What
both
is a
parts.
speaking objection?
Well, a speaking objection is, normally we would say, objection. Hearsay.
Relevancy,
or
whatever.
relevance. We would just give the legal term that we were saying that the reason we were objecting
violates
is because of this. A speaking objection is, objection, Your Honor. At no time did this witness say anything like this. Therefore, it's not relevant whatsoever. You're speaking to the jury about your case and giving them information as opposed to...
you're giving them information that has not already been given.
That's right.
That's where you
Sure.
can say
Information, not in evidence.
You can say anything that's been said, but you can't just say, you can't make up your own adjectives, and that's very relevant in our world today. But in the courts, you cannot make up your own adjectives.
But most judges would prefer, the objection,
Yes.
the legal reason that you're objecting,
That's it. Yep.
and that's it. And if the judge wants to talk about it,
Yeah.
he'll bring you up to the bench so that it's out of the purview of the jury.
Yeah.
They can't hear what you're talking about. And in this case, it's just objection and
But at the same thing, you have that balance between. This is something that all lawyers have to do: is that balance between, is it worth objecting to? And I know that kind of sounds crazy because you would just think that anything that's outside the rules you object to. But if you object to something, that's going to draw attention to it.
Absolutely.
And so this is a long trial. There's a lot of minutia. There's only a couple of little fireworks. Half the jury's probably not paying attention to this guy talking about that. They're not. And so if you object, then they go, oh, crap, this must be important. Now you give it some weight.
Sure.
Now you give it some authority. But I think the prosecution is letting this go, or and some of this stuff go. Not this one specifically, but letting some of this stuff go in just that regard.
Not being obstructionist.
It's not. Yeah.
Like
Look, this isn't hurting our case. Let's just let that kind of thing.
Some
go.
people might see it the same way y'all just like, okay, you're trying to make a bigger deal out of this
Right.
than it is.
And that's just how you gotta. It's just different tactics, and you gotta try to read the jury, and that's it's not an exact science.
Yeah. If they're looking at their watch, like
Right,
let's
yeah.
get to lunch kind of thing, they're not going to be happy about an objection. Well, let's see if anything else raises your eyebrows like it did mine.
No, I didn't.
All right. But without that dispatch log, without your dash cam, we would be relying on your dispatch log to be true and accurate. Is that right?
Other than what I'm saying that what happened, correct.
And do you think it's accurate otherwise?
Not in order, no. It's not. Not in order, no.
Other than
In
the
time.
order and the time that the officer's responding, is it correct in all other respects in your mind?
Can you rephrase?
Sure.
Say it one more time.
Let's take away the order and the time that the officers responded. Ignore that. Is the dispatch log otherwise accurate?
Yes.
Then pause it right there. This dude just said that he has not reviewed this document.
Yeah.
If you have not reviewed the document and you are a witness and they say or ask, is everything on this document correct?
that's a clue. We call that a clue.
You have to say, I don't know, because I am
haven't
looking at it for the first time right this
Let
second.
me put my glasses back on and look at it again.
You don't say, yeah, it's all right.
Because then this happens.
Take a look at the left-hand column where it's highlighted in green. What's that address?
Highlighting green?
On the screen, it's highlighted.
I'm sorry. I'm like, I didn't see anything.
I don't have the document.
That's okay. It says 32 Fairview.
Did you arrive to 32 Fairview Road?
No.
You arrived to 34 Fairview Road,
That's correct. Yep.
So that even the location on the dispatch log is faulty. Is that right?
Sure, yep.
All right, pause it, Chace. So, what I want to bring up about this is that they've just ruined this dude's credibility, and why he's important to the prosecution is because he's one of the few people in this case that doesn't have a blood relation to somebody else. I mean, that's the truth. Everybody else is commingling or something. I don't know. But the problem. There is an easy explanation for the same thing you just said, Shawn. There's an easy explanation for why the times are different. There's an easy explanation for why the address is wrong. He doesn't explain that at all. The address is wrong because you're dealing with an officer, and usually you don't put officers' addresses out into the public, especially when it's a community like this, to kind of do you a favor. I'm not trying to get your information out there. Officers of the law don't like that. I know some of them, and they purposely leave their address out of the public purview.
Well, I mean,
that's an explanation, but you can't just leave it sitting out there. You can't.
I haven't heard the 911 calls that were made. I know that they were probably already introduced, but imagine if you drove to a place and found a body on the side of the road in the middle, and you look up, and the first mailbox that you see has a 32 on it.
Right.
And you tell them 32
That's where
Fairview
I am.
Road.
Yeah.
And that's where they're going. Even though you're standing in front of 34 Fairview Road, I mean, it's just, things that...
But just explain that.
Sure.
Explain that. Like, don't just let it sit out there like an old matzo ball.
But this
just take it out.
But this is an example why people don't necessarily like attorneys too much, because We are making a point about the fact that it's wrong, but you're sharpshooting them. You're putting them in a situation. I'm here to tell the truth about what happened, but then you were able to like show that and make it look as if you're lying about all these pieces of evidence. Now, should all these things be right? Absolutely.
Well, and
absolutely, but do they make a difference?
There's such a balance to that that you have to pick and choose, because you can turn a jury against you.
Absolutely.
If you continue
tinker,
to pick on these nitpicky, what people refer to as technicality
Technicalities.
things, at some point the jury's going to say, no one gives a crap about
We've
that.
been here 4
No one
weeks,
gives a crap
you know.
about that. No one gives a crap about that. Let's
Yeah.
talk
happened?
about what happened.
Well, I'm glad you said that, because I think this next part, he addresses his testimony about what she said. I did this. This is my fault.
And this is the prosecution's fault for not correcting this beforehand or during the examination of that witness.
That morning, just hours after the incident, or minutes after the incident, she kept repeating, "Is he dead?" Right?
Yes.
You told Trooper Proctor that you could, quote, hear Karen Reid continually state, "Is he dead?" as the paramedics treated the victim. Officer Seraph then seen Karen inside her friend's vehicle, correct?
Correct.
In the 2 times that you were asked to reflect back on exactly what happened that morning, on January 29th and January 30th, both times you attributed only 3 words to my client having been repeated continually in her distraught state. "Is he dead?" Right?
Yes.
And she wasn't saying that calmly, I'm assuming.
Nope.
Matter of fact, you used the word she was severely distraught. Is that right?
That's correct.
On April 14th, 2022, months after this event, for the first time, you said, quote, and these are your words, tell me if I get them right. She, this is my fault. I don't know. She said, I can't believe this happened. I mean, she kept asking if he was going to die, if he's dead. And, I just basically said, we're doing the best that we could, end quote.
That's correct.
So in April of 2022, for the first time, you attributed the phrase, "This is my fault. I can't believe this happened," to my client, correct?
That's correct.
But nowhere in your official report did you say that.
That's correct.
And nowhere in your interview with Trooper Proctor the next day did you say that.
That's correct.
You think that was a pretty important omission on your part?
It was an oversight.
An oversight.
Yes, sir.
That a woman whom you made contact with, standing over the body of a fallen police officer, said to you, "This is my fault." Just missed that one. Yes?
Yes, I missed it. Yeah, I didn't write it down.
Just forgot to document the confession. Totally.
So, yeah, that's a problem. So
You think?
I mean,
Yeah.
this thing's ladled. I mean, it just.
So like that's a situation in which I would basically eliminate any benefit that witness ever gave me.
But I mean, Chace, don't you put some blame on the prosecution there?
A little bit, yep.
You have to. First, this witness was not ready.
No.
He'd never had reviewed the documents. He admitted that, and then he had changed his testimony, and nobody told him about it. Nobody went over it with him.
Yeah, I would have just at least handed him a transcript.
Show him,
yeah.
This is what you said. You got to correct this somehow.
or
they're gonna make you look like a fool.
Exactly how you did here.
You can't-
One or the other.
Yeah, and I just
Yeah.
it's something's missing on these witnesses, and it's just the lack of preparation, in my opinion.
Yeah, and I mean, have you guys seen anything on the prosecution side that has really sort of moved you and said,
None.
"Okay, this is good. This is good evidence in this particular case"?
No, I have no evidence, but I have I think a couple of witnesses have done relatively well handling the onslaught. But like I said, that is a circular mission from the defense. They're getting you in their fight, and I don't even know what the prosecution has given to show any evidence. Yeah. And their case is about to rest. I mean, it's a little bit embarrassing. I mean, you got if you're gonna bring a murder charge against someone, you got to bring some heat, man.
Well,
this isn't getting it.
So that's part of what the part that leads into this is Matt McCabe. And he's testifying at this point because, I mean, we're 16, I think 15 days into the trial at this point in the testimony.
Yes.
He's got a bunch of EMTs. We got witnesses that were there with her at the waterfall. They have police officers there at the scene.
The waterfall is the bar.
The waterfall
Yeah,
cafe, yeah, bar, right? And, you know, she is being charged with second-degree murder, and it's in part because she's DUI, behind the wheel, and gets angry and hits John O'Keefe. That's part of what has to be proven here, is that she had been drinking, right? To date, there is nobody that's given testimony that she was intoxicated, and that was also touched upon by the defense.
Because you're just fighting the defense. You're not proving your case.
Yeah.
You know, it's over and over again.
At the waterfall? No, they were only there for an hour, so.
Right. And they got there around 11, correct?
Give or take, yep, 11-ish.
And that bar is pretty strict about last call, correct?
That is correct.
And you spoke with both of them during the course of the night, correct?
Yes,
Neither John nor Karen was intoxicated in your view, correct?
Objection.
Can you answer that?
they were drinking. I don't know what the guideline of intoxication is, but they were drinking.
Do you recall testifying before the grand jury regarding this matter on April 26th of 2022?
If you have that, then I must have done it. I don't recall my questions, that question specific, but yes.
Right, well, I didn't ask you about the questions. I just asked if you recall testifying before the grand. See?
Yes.
I had just asked you if your memory of your observations of Karen Reid and John O'Keefe from January 29th would have been better on April 26th of 2022 than it would be today.
Yes, I think that's fair to say.
And that's because your memory doesn't get better over time, correct?
I don't know. I would say
Wow.
it's fair to say, yes, my
That's
memory
not
would be
great.
better that day.
That's also, just to put real quick, if you're on the jury
Yeah.
and they ask you a question like that, just say yes. Tell the truth. That's all I'm going to say. If they ask you a stupid question, hey, do you get older as you get old or younger as you get old? Then say
Older.
I get older.
Yeah.
And the question that I wanted to direct you to, just to put it in context, was did either of them, speaking about John and Karen, on this particular evening seem sort of overly intoxicated to you? Do you recall that question?
I don't recall the specific question, but if that's the question,
And your answer was no to that?
yes, if that's my answer, then it was no.
Yeah, so they put forth no evidence so far about her being intoxicated, him being intoxicated. And this is a long way into the trial
It is.
to not be having this. And unfortunately, I think that the biggest points that I've seen scored so far have kind of been by the defense.
Absolutely.
Sure.
Absolutely. It's like I said, it was right from the get-go of they framed it in, this is our case. This isn't the prosecution case. They took it over from the get-go.
Yeah, and one of the more, damning portions of the testimony from Matt McCabe, for me, was about the actual text that started to surface.
Mm-hmm. The family group text.
Exactly, and
He didn't do Matthew McCabe didn't do a very good job of being genuine. Came off kind of flippant. It's a little bit. It's not a funny situation, and he kind of a little too lighthearted, in my opinion.
Yeah, and I think that one of the problems is the fact. I mean, people are just not used to being put on a
Absolutely.
stand
No,
and
yeah,
grilled
yeah.
this way. It's,
Sure.
it's not. We always have to coach our clients. It's like, look, this person's going to make you mad because they're going to ask you inane, silly questions. And you're like,
Sure.
what's the point of this? And you're going to end up getting frustrated with them. And I think that's a little bit of what you're seeing here. And just give me 1 second. I'm going to play this part of the Matthew McCabe.
I was just going to say that, on some major cases, obviously I know a lot of people in law enforcement still, are friends with them, worked with them in the past.
Sure.
And have had,
Sorry,
hearings with them. And before the hearing, saw them in the courtroom or the hallway and just, pat them on the back and said, "Hey, bud, this is going to be real uncomfortable." And they're like, "I know, dude. Just do your job." They know there's nothing personal about it, but they know that I'm going to bring up things that
You have to.
they should have done.
Yep.
And I'm going to bring up things that
Or they could have done.
Sure.
That's a big one, like you were saying earlier. Sometimes if that's all you got, that's all you got.
Well, at least so like that. Yeah, we're talking about the and maybe I'll save this for the next time. But when Jim McCabe was questioned about that 240 something, 243 Googling of how how's long to die in the cold, right? She basically just said that the data's wrong.
Yep.
Right, and so that's going to leave it to basically
that's all you can do, man.
Well, saying it's going to leave it to an issue between the experts at that stage, right? Well, that'll do it for this time on Layman's Law School. If you enjoyed today, please like and subscribe. Hit that notifications button so you know when we've got a new video uploaded. And follow along as we continue following this Karen Reid trial.
If you got questions, leave them in the comments. We'll try to get to them.